So good afternoon all, good afternoon, Jai Hind. A very good afternoon to each one of you. And in this session, now we'll start off with some expected PYQs as well as some expected questions of the Indian polity for your upcoming prelims 2026. So good afternoon all, good afternoon, Jai Hind. I hope all of you who have joined me now in this session, please do let me know, am I audible loud and clear? बताइए भाई, do let me know, am I audible loud and clear? So today's session will have everything that you require to finally brush up your last minute topics, important concepts for your upcoming prelims 2026 of Indian polity. So this session will be a very important session, and after the end of the session, I'll also share an annotated PDF of today's session in my Telegram channel. And the link to it is Sharad_Mudgal_StudyIQ. Okay. So we'll be starting off with this session now. Please do mark your attendance in the comment section. Please do let me know, am I audible loud and clear? And then I'll start off with this session. Okay. In this session, we'll quickly solve the questions, and I'll also keep sharing the important factual information that is required to be remembered during the examination as well, because every question is not just to practice. Okay, every question you must take it as a revision of a specific topic. So please do make sure that you undertake entire background information as well, which is required to solve the questions. Clear? So good evening all, good evening, Jai Hind. Hope each one of you are doing great. Chaliye. So we'll move on in this session, and before starting off with this question, let me remind each one of you that from tomorrow, that is 7th of May, GS Foundation batches for the Civil Services 27 and 28 exams are being launched by StudyIQ, and you can avail maximum discount by using the code SRM Live. Okay, so do use this code to avail maximum discount. Along with this, the GS Foundation batches are available in English, Hindi as well as in English, a combination of English and Hindi language. Clear? So I would request you to please do share this session amongst your friends so that every serious aspirant can make best use of this session. Chaliye. So good afternoon all. So let us start off with our discussion. Okay, and in this session you will have all the questions, including the PYQs as well as the expected questions for this year's prelims, and will include all topics, all high weightage topics from where the questions are being asked regularly. Clear? Chaliye. So let us start off with our discussion. The first question: consider the following institutions in India: the National Human Rights Commission (NHRC), Central Vigilance Commission, Niti Aayog, Central Information Commission, National Commission for Scheduled Castes. How many of the above institutions are neither a statutory body nor a constitutional body? बताइए भाई in comment section which of these are neither these offices. You have to tell which of these are neither statutory nor constitutional. Okay. So now when we have a look over these, okay, the first option that is given here is the National Human Rights Commission. Okay. So this National Human Rights Commission is essentially established in 93 under the Protection of Human Rights Act. Clear? So this office has been established under Protection of Human Rights Act 1993. So it is a statutory office. Okay, so it is a statutory office and it has been established under a statute of Parliament. Clear? Second, Central Vigilance Commission. Again, a very important topic. Body originally established in 1964 by an executive resolution. So initially, this CVC was established by an executive order. Okay, but later on it was given a statutory status by the Central Vigilance Commission Act 2003. Clear? So again it becomes a statutory office. Clear? Now, third is the Niti Aayog. Okay, so Niti Aayog, erstwhile called the Planning Commission of India. Okay, so it has been established through an executive resolution and does not include any statute or a constitutional provision. So it is not backed by any act of parliament or any constitutional provision. Fourth comes the Central Information Commission. So this CIC has been established under 2005, has been established in 2005 under the RTI Act. Clear? Fifth, the National Commission for Scheduled Caste. So it is a constitutional office. Okay, and this office has been established under Article 338 of the Constitution. So the answer is only option 3, Niti Aayog. So answer is option A, only one. Okay. So in this entire session, in every question, I'll keep discussing the background details. Okay. So you need not revise the topic later on, and the entire topic will be revised here, now and here itself. Clear? Chaliye. So I would request you to please do keep a pen and paper with you so that you can also note down every important detail. Okay. So moving ahead, next question. Consider the following statements. In India, Panchayati Raj institutions are governed by state-specific acts that outline their composition, powers, functions, and administrative procedures. Statement second, local government is a subject enumerated under the state list in 7th schedule of the Constitution. Which of these are correct? Option A, both statement 1 and 2 are correct and statement 2 is the correct explanation. B, both statement 1 and 2 are correct but 2 is not the correct explanation. C, statement 1 is correct but statement 2 is incorrect, and D, vice versa. बताइए, which of these regarding the Panchayati Raj institutions okay, and do keep mentioning the respective important articles also. Okay, so the best way to remember articles is whichever question you are solving, do write down the article that is associated with it. Okay. Now, the first statement, in India, Panchayati Raj institutions are governed by state-specific acts that outline their composition, powers, functions, and administrative procedures. Now, this statement is absolutely correct. Clear? Because according to Article 243G, okay, so it is according to Article 243G of the Constitution, introduced by the 73rd Amendment Act of 92, states have the authority to enact their own Panchayati Raj Acts. Clear? And these provisions encompass everything. Now, statement 2, local government is a subject enumerated under the state list in the 7th schedule of the Constitution of India. So, statement 2 is also correct. The subject of local government falls under the state list in the 7th schedule. Now, this means that states have the authority to legislate them to legislate upon matters related to the local government, including the panchayats. Clear? Now, this statement 2 is the correct explanation. Okay, thus the answer herein is option A. Okay, so option A herein is the correct answer. Clear? Okay, so somebody had initially said option C, but the correct answer is option A. Clear? So, constitutional provisions empower states to pass their own Panchayati Raj Acts. Okay, and these acts specify the establishment and functioning of panchayats within their jurisdiction. Okay, moving ahead, moving further, consider the following languages: Tamil, Gujarati, Malayalam, Bengali, Kannada, Telugu. How many of the above languages have been given the status of classical languages in India? Classical languages. So, we are not talking about the official languages, we are talking about the classical languages. Okay, you must remember what does classical language here means. Okay, and how classical languages are accorded the given status. Okay, so now all of you who are part of this session, I would request you to please answer the questions. Okay, take up around 20 seconds, 30 seconds max to answer the question. Now, this will help you to properly decide and eliminate the required and the not required options. Okay, now in this situation, classical languages. Now, if we talk about classical languages, a separate category called classical languages was created in 2004. Okay, now it was then that the government of India had decided to create a new category of language called the classical languages, and in 2006 the criterias around the classical languages were also laid down. Okay, now in this deciding this classical languages, it is the Ministry of Culture which has the responsibility to decide these. Clear? Now, when we talk about the classical languages, herein Tamil was the first language in India that was granted the status in 2004 itself. Moreover, Tamil specifically qualifies due to its long history, long records, long text that has been written. Okay, so it was said that Tamil, Tamilian history dates back to around 2000 years. Clear? Now, option 2 is Gujarati. Clear? So, Gujarati is an important regional language, but that it has not been designated as a classical language. So, option 2 is incorrect. Okay. Now, again, option 3, Malayalam is a correct option. Okay. Malayalam was recognized the status in 2013. Clear? So, it has got some characteristics with Tamil, but it has a very distinct script. Okay. Fourth comes Bengali. Okay, now fourth Bengali is also incorrect. Okay, so Bengali again is a very important regional language, rich literary heritage, but still it is not a classical language. Clear? Point option 5, Kannada is correct. So it was declared a classical language in 2008 itself. Okay. Next is Telugu. Telugu again received the same status in 2008. Okay. So the correct answer, how many of the above languages have been given the status of a classical language? The answer is option B, only 4. Okay. So answer herein is option B. Clear? So good afternoon all, good afternoon, Jai Hind. So all of you who are joining me now in this session, I would request you to please do share this session amongst your friends as well. Okay, and I'm just trust me, you will gain a lot in this session, and I'll make sure that your entire polity gets revised in this. Okay, so please do share this session with your friends and do not forget to like this session also. Okay, moving ahead, the next question, on to the next. With reference to the Panchayati Raj institutions, consider the following. Okay, currently more than 2/3 of states in India have expanded reservations for women in panchayats at village level to 50%. Okay, just go through these statements very carefully. Okay, Bihar was the first state in India to increase the reservation for women to 50% in panchayats at the village level. Third, no state in India has established minimum educational qualification for contesting panchayat elections. Okay. Now, just remember, UPSC is always interested in the exceptions. Okay, so they will not ask questions directly from a concept. They'll ask questions around the exceptions that have been given in the concept. Okay, बताइए. Which of these? Okay, so we just now majority of you might be knowing only the prominent concept. Okay, so 73rd Amendment Act of 92 had mandated that at least 1/3 of seats in the Panchayati Raj institutions have to be reserved for women. But over the years, various states have taken progressive steps to increase the reservation to up to 50%. Okay, now, first statement, currently more than 2/3 of the states in India have expanded reservation for women in panchayat at the village level to 50%. Okay, So now, presently, 21 states out of a total of 28 states. Clear? So 21 states out of a total of 28 states have 50% reservation for women at panchayat level. Now this is over two-thirds. Clear? So first statement is correct. Second, Bihar was the first state in India. Okay? To increase the reservation for women to 50% in panchayat at the village level. Okay. Now herein if we see, if we see, again this statement is absolutely correct. Clear? Bihar was the first state. Okay. Now no state. Okay. So going by the preferred elimination techniques for the UPSC, no state in India has established minimum educational qualifications. Clear? Now this statement is incorrect. Now can you please let me know any state that has implemented minimum educational qualification for the panchayat elections? Any state? Any state according to you that has minimum educational qualifications for the elections to the panchayats? Okay. So the correct answer to this is Haryana. ठीक. So answer is option A, 1 and 2 only. Clear? 1 and 2 only is the correct answer here. ठीक. Now, moving ahead, next. With reference to household consumption expenditure survey, okay, consider the following. Okay. Now, this question relates to survey, okay, brought in last year, okay, but it had some important information. Thus, I have added this question as well. Okay. Quickly, we'll just go through this. With reference to the Household Consumption Expenditure Survey, HCES, consider the following. The survey is conducted by National Statistical Organization under the Ministry of Stats and Program Implementation. Second, the average monthly per capita consumption expenditure in households is highest in Chhattisgarh for rural areas. Okay. So, first statement is correct. Okay, it is conducted by the NSO under the Ministry of Statistics Program and Implementation. Okay. Now, second statement is incorrect because as per the Household Consumption Expenditure Survey, the average monthly per capita consumption expenditure in Indian households had risen to over 33%. Okay, and amongst them, the highest is in Sikkim. Clear? So, highest is in Sikkim and lowest was in Chhattisgarh. Clear? So correct answer is option A, 1 only. Clear? Moving ahead, next. With reference to the Union Territory of Jammu and Kashmir, consider the following. The Legislative Assembly of Jammu and Kashmir can make laws on any subject mentioned in state list of the 7th schedule of the Constitution except on subject of land. Second, the Electoral College for the President of India does not include members of Legislative Assembly of Jammu and Kashmir. बताइए, as per Jammu and Kashmir Reorganization Act of 2019, बताइए, बताइए. Okay. Now just have a look. The Legislative Assembly of Jammu and Kashmir can make laws on any subject. Now this was a very wide statement. Okay. And such wide options are usually incorrect. Okay. So first statement here is incorrect. The Legislative Assembly of Jammu and Kashmir has the authority to enact laws on subject listed in state list except public order and police. Clear? So this is incorrect. So this is except public order and police. Okay. Now, option 2, the Electoral College for the President of India does not include the members of Legislative Assembly of Jammu and Kashmir. Okay. Now, why this statement is correct? बताइए. Why this statement is correct? Can any one of you tell me in the answers? बताइए भाई. So, majority of you, only Bittu God has answered it correctly. Okay. Now also tell me why. Why? Why the Electoral College? Okay. Now, why it is not included? Because this goes as per the definition of Article 54 in the Constitution. Okay, because it goes as per the definition given under Article 54. Clear? Jammu Kashmir is a union territory. Clear? Okay, but this has to be interpreted as per Article 54. Now, Article 54 specifically mentions only union territories of NCT of Delhi and Puducherry as eligible to be part of the Electoral College. So, there is no word about the newly formed union territory of Jammu and Kashmir. Okay, and thus in the presidential elections, the members of Legislative Assembly of UT cannot participate. Okay, so second is correct. So answer is option B, 2 only. Okay, so this is an important information. So these are some important areas that I'll be covering up in this session, and I want each one of you to please keep noting them down. Okay, moving ahead. Next, according to the Constitution of India, reservation of seats in Panchayat elections for scheduled tribes shall not apply to which of these states? बताइए. बताओ भाई, which of these states? Okay. Now, herein if we see the options that are given, clear? So, when we talk about the reservation of seats for scheduled caste and scheduled tribes in every panchayat, okay, then it is as per Article 243D of the Constitution, clear? So, as per Article 243D of the Constitution, it is not applicable to the state of Arunachal Pradesh. Clear? So the reservation of seats in panchayat elections, okay, for scheduled tribe, the exception is Arunachal Pradesh. Clear? Chaliye. Moving ahead. Okay. Acha. Moreover, in Article 243M, okay, the clause specifically states that provision of 243D regarding the reservation of seats do not apply to Arunachal Pradesh. Clear? Moving ahead. Next. Consider the following statement. Statement 1. The 73rd Constitutional Amendment Act of 92 transformed India's governance from a representative system to a participatory system of governance. Okay. Second statement, the 73rd Constitutional Amendment Act of 92 mandated the reservation of seats for scheduled caste and scheduled tribes in Panchayati Raj institutions. Okay, which of these is correct in respect to the above statements? बताइए. Okay. Now, the 73rd Amendment transformed India's governance from a representative system to a participatory system. तो बिल्कुल सही, बिल्कुल absolutely correct. It talked about the decentralization. Okay. So, first statement is correct. Second, the 73rd Amendment Act of 92 mandated the reservation of seats for scheduled caste and scheduled tribes in Panchayati Raj institution. That is again correct, clear. But the statement 2 does not explain the first statement. Okay, so the answer is option B. Okay, the answer is option B here. Okay, moving ahead, next. With reference to the historical development of Panchayati Raj institutions in India, consider the following statements. Okay. The Royal Commission on Decentralization of 1909 recommended that the villages in India should be regarded as the basic units of local self-government institutions. Second, Balwant Rai Mehta Committee recommended the three-tier system of government for the first time in independent India. बताइए. Panchayati Raj institutions have always been a sure shot topic in the exam. Okay, so please do practice this topic, do revise this topic again and again. बताइए. Good. The Royal Commission on Decentralization of 1909 recommended that the villages in India should be regarded as the basic unit of local self-government institutions. That is correct. Second, the Balwant Rai Mehta Committee recommended the three-tier system of government for the first time in independent India. This is again correct. Both the statements are correct. Answer is both 1 and 2, option C. Clear? Okay. So, the Royal Commission on Decentralization, okay, that was brought in 1909, was headed by Hobhouse, okay, and it was then that he had recognized the importance of local self-government institutions like the panchayats for the rural development in India. Okay, and this commission had recommended that village should be regarded as the basic unit of local self-government. Clear? Moving ahead, next. With reference to the Panchayats extension to scheduled areas, Pesa Act 96 consider the following. The power to enforce prohibition or to regulate and restrict the sale and consumption of intoxicants, the authority to own and manage minor forest produce. Third, the power to prevent alienation of land in the tribal areas declared under Schedule 6 of the Constitution. Which of the above powers are conferred on Gram Sabha under Pesa Act of 96? बताइए. This Pesa Act is again very, very important. Right. Okay. The power to enforce prohibition or to regulate and restrict the sale and consumption of intoxicants. Now, this is correct. Clear? So, this Pesa Act is basically, it grants Gram Sabha several exclusive powers and responsibilities. Okay, so this is done in order to enhance their role. Okay. Second, the authority to own and manage minor forest produce. This is again correct. The power to prevent alienation of land in the tribal areas declared under Schedule 6 of the Constitution of India. Clear? So this statement is incorrect because under the Pesa Act of 96, Gram Sabha has the power to prevent alienation of land. Okay, and it is declared under Schedule 5 and not under Schedule 6. Clear? So this is Schedule 5. Answer is option A, 1 and 2 only. Clear? Moving ahead, next. With reference to the State Finance Commission, consider the following statements. The 91st Constitutional Amendment Act of 2003 provided for the establishment of State Finance Commission. It works under the overall supervision of the Finance Commission of India. Third, it makes recommendations to the President regarding grants in aid to the municipalities from the Consolidated Fund of India. बताइए. I would request each one of you to please participate. Okay, please keep answering. बताइए. Okay. The 91st Constitutional Amendment Act of 2003 provided for the establishment of State Finance Commission. Okay. So the State Finance Commission, okay, it was provided by the 73rd Amendment Act. How come it will be related to 91st? Okay. It was 73rd Constitutional Amendment Act of 1992. Okay. Now, in this, okay, Article 243I of the Constitution provides for the constitution of State Finance Commission. Okay, whereas Article 243Y, okay, states that Finance Commission under 243I can also review the financial positions of municipalities. So it has to be 243I and 243Y. ठीक? Now it works under the overall supervision. This is again incorrect. Clear? So this statement is again incorrect. Okay. So second does not hold true. Third, it makes recommendations to the president. Now the State Finance Commission has got nothing to do with the president. It makes recommendations to the governor. So third is again incorrect. The answer is option D, none of these. Clear? Option D, none of these is the correct answer. Chaliye, next. With reference to the Panchayat extension to scheduled areas, consider the following. It was enacted on the recommendations of Bhuria Committee. It is not applicable in the state of Assam. Which of the statements given above is or are correct? बताइए. Which of these? Okay. Now, the correct statement, it was enacted on the recommendations of Bhuria Committee. अब ये बिल्कुल ठीक है. Now, this is absolutely correct. It was based upon the recommendations of Bhuria Committee, and this committee was established in 94 to work out the details, okay, of a similar structure. Second, it is not applicable in the state of Assam. Which of the following statements above is or are correct? So that is again correct. The Pesa Act is not applicable for the state of Assam. So answer is option C, both 1 and 2. Clear? Chaliye. Moving ahead, next. Which of the following is considered as the primary instrument for effective implementation of Panchayat extension to Scheduled Areas Act? बताइए, primary instrument. Primary instrument means that which of these institutions have got the absolute power under the Peace Act. Which of these has got absolute powers under the Pesa Act? Okay. Now, if we see, the correct answer here is option A, Gram Sabha. Okay. So, Gram Sabha has been accorded the prime place in the Pesa Act, and it is considered to be primary instrument for implementing Pesa for giving controls to the tribals. Okay. So, absolute powers have been granted to the Gram Sabha. Okay. Next. Consider the following statements. State 1. Executive power of center to give directions to the states is wider in scheduled areas under 5th schedule of constitution when compared to non-scheduled areas. Second statement, in scheduled areas, the executive powers of the central government extends to all subject matters, including subjects in the state list of 7th schedule of the Indian constitution. So, which of these statement is correct? Please do let me know. The executive powers of center to give direction to the states is wider in scheduled areas under 5th schedule when compared to the non-scheduled areas. Chaliye, having a look over this, executive powers of the center to give directions to the states is wider in scheduled areas under 5th schedule when compared to the non-scheduled areas. Clear? So this statement is correct because executive powers of center to give directions, okay, we can see that the central government can pass regulations, okay, upon one or more number of subjects across the schedule 7. Okay, so for scheduled areas in comparison to non-scheduled areas, it can give overwhelming legislations, regulations. Clear? So first statement is correct. Second, in scheduled areas, the executive power of central government extends to all subject matters, including subjects in the state list of 7th schedule of Indian Constitution. So this is correct. Clear? Now, why does the executive power of center is wider? Okay, because the executive power of central government extends to all subject matters. Okay, so what is specifically wider here is that power extends to all subject matter, even those which are within the domain of the state government. Okay, so this is correct, and thus answer is option A. Okay, I hope all of you have got it because it extends to subject matter. Okay, in across the union list, state list, and the concurrent list. Thus, their power is wider. Okay, so answer is option A. ठीक. Next, consider the following statements regarding the scheduled areas designated under the 5th schedule of the Constitution of India. Okay. First, Indian Constitution is silent on criteria for declaring an area as scheduled area. Second, provisions of Constitution of India relating to the scheduled areas may be amended by the Parliament through a simple majority. बताइए. बताइए भाई, which of these? Now, if we have a look over this statement, the criteria for declaring an area as the scheduled area under 5th schedule is not defined in the Constitution of India. So, this is correct. Clear? And this is as per the Scheduled Areas and Scheduled Tribes Commission. Okay. So, first statement is correct. Okay. Second, provisions of Constitution of India relating to the scheduled areas may be amended by the Parliament through a simple majority. Okay, so under 5th schedule, it can be amended, altered, or repealed by the Parliament, and this is not considered an amendment under Article 368. Thus, it can be brought out by simple majority only. So, answer is option C. ठीक है, ऑप्शन सी हेयर इन इज द करेक्ट आंसर. ओके, नेक्स्ट. With reference to the Tribes Advisory Council constituted under the 5th schedule of the Indian Constitution, consider the following statements. It advises the governor of the state on the matters relating to the welfare and advancement of scheduled tribes when asked by the governor. The advice tendered by TAC to the governor on making regulations relating to the governance in the scheduled areas is binding. Which of these statements above are correct? Tribal Advisory Council. Right. With reference to the Tribes Advisory Council, answer these. Good, Krishna Sama. Now it advises the governor of the state on the matters relating to welfare and advancement of the scheduled tribes when asked by governor. Second, the advice tendered by TAC to the governor on making regulations relating to governance in scheduled areas is binding. Clear? So now this statement has got multiple connotations. Okay. Always remember that it is compulsory for governor to consult the council before making any any decision, but such an advice is not binding upon the governor. Okay, so statement 2 is incorrect. I'll just write it. Okay, so answer is option A, one only. Chaliye, moving ahead. The 6th schedule of the Constitution of India provides for a district councils for each autonomous district. In this context, consider the following. District councils in each autonomous districts have the power to establish primary schools, constitute village councils and courts. Third, impose taxes on professions and trade in the area. बताइए. Which of these? Good. Now, it can establish primary schools, it can constitute village councils and courts, and can impose taxes on professions and trade in the area. So answer is option D, 1, 2 and 3. Clear? Chaliye. Moving ahead. Next. Consider the following statements. The inner line permit is not mentioned anywhere in the 6th schedule of the Constitution. Recently, Ladakh Union Territory was included under the 6th schedule of Indian Constitution. Now, inner line permit has also been a regular in the exam. बताइए. Now it is just Bittu and Krishna answering. I want more students to participate, more students to answer. Okay. Now, the inner line permit is not mentioned in the Constitution. Now, when we have a look over this first statement, the inner line permit is entirely a different mechanism, and it is used to regulate entry into certain areas to protect indigenous communities and is governed by the Bengal Eastern Frontier Regulation. Okay, so it is correct. It is under Bengal Eastern Frontier Regulation. ठीक. Second, recently Ladakh Union Territory was included under the 6th schedule of the Indian Constitution. Okay. Now this is incorrect. Why? Because Ladakh has not been granted 6th schedule status. Ladakh mein we had seen that there have been protests and they are demanding the 6th schedule status. Okay, that has not been given. So no official decision has been made yet. So second statement is incorrect. The answer is option A only, 1 only. Clear? Chaliye, next. In the context, just wait. Chaliye. Now, in the context of powers of the governor under the 6th schedule of the Indian Constitution, consider the following statements. The governor can modify or annul any resolution passed by the district councils if it is deemed detrimental to the interest of scheduled tribes. Second, the governor has the power to establish regional councils for areas within the autonomous districts if there is a significant presence of different tribes requiring distinct administration. Third, the governor may by notification direct that any act of parliament shall not apply to an autonomous district or autonomous region in the state of Meghalaya. बताइए. Okay. Now, when we talk about this, okay, so especially you must remember, okay, at times the students end up getting confused with the states covered. Okay, Now, if we talk about this, the governor can modify or annul any resolution passed by the district councils if it is deemed detrimental to the interest of scheduled tribes. Okay, so this first statement is correct. Clear? Second, the governor has the power to establish regional councils for areas within the autonomous districts if there is a significant presence of different tribes requiring distinct administration. Okay. Now, this statement is also correct. Third, the governor may by notification direct that any act of parliament shall not apply to an autonomous district or autonomous region in the state of Meghalaya. Okay. Now, this statement is incorrect. Okay. Why this statement is incorrect? Because under the sixth schedule, okay, it is not the governor, but it is the president. Okay, it is not the governor, but it is the president, okay, who has the power to direct that any act of parliament shall not apply to an autonomous district or region in the state of Meghalaya. Clear? Chaliye, moving ahead. With reference to cooperative societies in India, consider the following statements. First, multi-state cooperative societies are concurrent list subject under 7th schedule. Gujarat has the highest number of registered cooperative societies in India. Third, the mission of Sehkar Se Samriddhi of Ministry of Cooperation aims to ensure equitable and widespread growth of cooperative societies. बताइए. Okay, good, Krishna. Now, the multi-state cooperative societies are a concurrent list subject under 7th schedule of the constitution. Okay. Now, cooperative societies are under the state list. Okay. So, these are not under the concurrent list, but these are under the state list. Okay. Second, Gujarat has the highest number of registered cooperative societies in India. Okay. Now, Gujarat has got very high number. Okay. But the highest number of cooperative societies are in the state of Maharashtra. Okay. Are in the state of Maharashtra. Over 2 lakh. Okay. Over 2 lakh societies have been registered. Third, the mission of Sehkar Se Samriddhi of Ministry of Cooperation aims to ensure equitable and widespread growth. Now, this is correct. So, the answer is option C, 3 only. Clear? Moving ahead. Next. With reference to National Cooperative Development Corporation, consider the following statements. It is a statutory body established by an Act of Parliament. Second, the Government of India provides financial assistance to cooperatives through the NCDC. Third, its primary focus is on promoting and developing cooperatives in the agricultural sector only. Which of these statements are correct? बताइए. NCDC. Okay. Now, it is a statutory body established by an Act of Parliament. So, yes, NCDC was established in 1963, okay, and it is under the Ministry of Cooperation, okay. So first is correct. Second, the Government of India provides financial assistance to cooperatives through the NCDC. This is again correct. Its primary focus is on promoting and developing cooperatives in agricultural sector only. Now this only statement ended up making it an incorrect statement. Clear? Now NCDC does not support cooperatives in agriculture only, but across various sectors. Okay. Now various sectors can be for women and weaker sections, can be for value addition marketing also. Okay. So this third is incorrect. The correct answer is option B, 1 and 2 only. Okay. Moving further, moving ahead. With reference to the union territories in India, consider the following statements. All members of the legislative assemblies of union territories of Delhi and Pondicherry participate in the presidential election. Okay, Delhi and Puducherry. Okay. Participate in the presidential election. As per Constitution of India, the total maximum representation from all union territories to Lok Sabha is 30. The Panchayati Raj system is constituted in all union territories except Delhi. बताइए. बताइए भाई. With reference to the union territories in India. Okay. So all members of Legislative Assembly of Unity of Delhi and Puducherry participate in the presidential election. Okay. So it is the elected members, okay, who participate in the presidential election. Okay, the nominated members do not. Clear? Moreover, they do not have the right to vote. Okay, so first statement. Okay, so as previously also we have discussed, as per Article 54 of the Constitution. So first is incorrect. Okay. Second, as per Constitution of India, the total maximum representation of all union territories to Lok Sabha is 30. So what is the number? What is the number? What is the total representation of union territories in Lok Sabha? Please do let me know in the comment section. What is the total representation of UTs in Lok Sabha? Now this is not 30, but it is 20. The Panchayati Raj system is constituted in all UTs except Delhi. Okay. So this statement is again correct. The Panchayat system exists in all states except Nagaland, Meghalaya, Mizoram. Okay. So exceptions are these three states plus exception in union territories is Delhi. Clear? So the answer is option D, 3 only. Okay. Moving further, moving ahead. Constitution of India gives a power to Parliament to constitute a body to function as a legislature for the Union Territory of Puducherry. In this context, which of the following types of legislative body is created for Puducherry under Government of Union Territories Act 1963? बताइए. special provisions बताइए. Okay. So yes, the correct answer here is option B, partly nominated and partly elected. Clear? So this is mentioned, okay, as per Article 239A. Okay, so it empowers the Parliament to create specific bodies for certain duties. Okay. Chaliye, next. With reference to the special provisions with respect to UT of Delhi in Constitution of India, consider the following. All the members of Legislative Assembly of Delhi are directly elected. The matter relating to the division of the National Capital Territory into territorial constituencies is regulated by law of Parliament. The Legislative Assembly of Delhi is empowered to make laws on any of the matters enumerated in the state list of 7th schedule of the Constitution of India. Which of these is or are correct? बताइए. Okay. Now, all the members of Legislative Assembly of Delhi are directly elected. Now, this statement is correct. Okay. So, basically, we can see that in this there are 70 seats and all members are chosen directly. Okay. The matter related to division of NCT into territorial constituencies is regulated by the law of the Parliament. Clear? So, Article 239 AA empowers the Parliament to regulate these matters. Okay, and it can regulate the total number of seats. Currently, the parliamentary constituency, legislative assembly is divided into 13 seats in the assembly. Okay. Next. Third, the Legislative Assembly of Delhi is empowered to make laws on any of the matters enumerated. Now, this is again incorrect. Clear? So, it is not upon any matter. Okay, it is not upon any matter. The Legislative Assembly is not empowered to make laws on all matters. Okay, so it is again as per Article 239 AA, the Assembly has the power to make laws on all matters except public order, police and land. Clear? ठीक. So answer is option B. Next. In which of the following situations can the Lieutenant Governor of Union Territory of Puducherry issue an ordinance when the legislature is in recess? Second, resolution. 3, suspension. बताइए. Okay. So, when the legislature is in recess. Okay. Now, in cases of dissolution, okay. Just remember, the administrator of Puducherry can promulgate only when legislature is in recess. Okay, so Article 239B deals with these powers of administrator. So it is like when the houses are not in session. Clear? So answer is option A, one only. Next. With reference to Maritime Anti-Piracy Act 2022, consider the following. It empowers the Indian Navy to board, seize and arrest pirates operating in the high seas. It allows for the trial of pirates to proceed even if they are not present in court. Third, the act provides for provision of death penalty to a person for causing death during an act of piracy. बताइए. Maritime Anti-Piracy Act. Okay. Now it empowers the Indian Navy to board, seize and arrest pirates operating in the high seas. Okay, so this is correct. It allows for the trial of pirates to proceed even if they are not present in the court. Okay. Now this is incorrect. Now Maritime Anti-Piracy Act did not include the provision for trial in absentia. Clear? So this does not mean that the trial will be allowed even if the accused is not present. Okay, so second is incorrect. Third, the act provides for provision of death penalty to a person. Yes, this is correct. So answer is option C, 1 and 3 only. Clear? Option C, 1 and 3 only is the correct answer. Next. With reference to federal structure of Constitution of India, consider the following statements. Statement 1. Article 371 of the Constitution tilts Indian federalism towards asymmetric federalism up to some extent. Second statement, Article 371 of the Constitution grants special provisions and unique powers to certain states of India. बताइए. So please answer. Article 371 and the idea of federalism. Okay. So the Article 371 of Constitution tilts Indian federalism towards asymmetric federalism up to some extent. Okay. Now, why is this correct? Because the principle of asymmetric federalism difference, it creates different, or we can say that it acknowledges the differences between the states. Okay. And then it allows the central government to make special provisions for some states. Okay. Second, Article 371 of Constitution grants special provisions of unique powers. So that is correct. Answer is option A. Okay, answer is option A here. Moving ahead, next. Which of the following is authorized to put union territory under the jurisdiction of High Court of adjacent state? बताइए. बताइए. So this is quite direct. Okay, this option is very direct. It is option A. Okay, it is the Parliament. ठीक. Next. Consider the following statements regarding the special provisions for the state of Manipur under the Constitution of India. Governor shall submit report to the President regarding administration of hilly areas of Manipur. Second, central government can give directions to the state government regarding administration of hill areas of Manipur. बताइए. Okay. Now, when we talk about this, Article 371C is around the state of Manipur. ठीक. अब the term hill areas does not mean the hilly region as per the topography. Clear? The hill areas means those areas which president may by orders declare or specify. ठीक. Now, let us go through the statements available. Okay. Governor shall submit report to the president regarding administration of hill areas of Manipur. That is correct. Second, central government can give directions to the state government regarding administration of the hill areas of Manipur. That is again correct. ठीक. So answer is option C, both 1 and 2. ठीक. Option C, both 1 and 2 are correct. Okay. So the special provisions for Manipur are given under Article 371C. ठीक. Next, with reference to the safeguards available to civil servants in India, consider the following statements. Criminal proceedings cannot be instituted against civil servants for any act done without the prior sanction of the appropriate authority. Second, a civil servant cannot be dismissed or removed by an authority subordinate to the one that appointed him or her. Third, generally a civil servant cannot be removed without a fair inquiry and the opportunity to defend against the charges instituted upon him or her. बताइए. About the civil servants and the immunities given to them. बताइए. Now, when we talk about the civil servants, okay, so yes, that is correct. Article 311. Okay. Now, criminal proceedings. Okay. Ab criminal proceedings cannot be instituted against civil servants for any act done. Now, this is incorrect. Okay. Supreme Court has ruled that public servants may be prosecuted without prior approvals. ठीक. Now, second, a civil servant cannot be dismissed or removed by an authority subordinate to the one that has appointed him or her. Again, correct? Clear? So, as per Article 311, a civil servant cannot be dismissed or removed by an authority subordinate to the one that has appointed him. Okay. Third, generally, a civil servant cannot be removed without a fair inquiry. Okay. So, herein, again, if we see, again, as per Article 311, civil servants are generally entitled to a fair inquiry and must be given a reasonable opportunity to defend themselves. ठीक? So, this is correct. Answer is option B, only 2. Option B, only 2 is the correct answer. चलिए next. Consider the following statements regarding special provisions for scheduled tribes under the Constitution of India. President may, by public notification after consultation with the governor of the state concerned, specify tribes as scheduled tribes relating to that state. Second, President may by notification include or exclude scheduled tribes from the list of scheduled tribes recognized at central level. Third, Indian Constitution is silent regarding the criteria for specification of a community as scheduled tribes. Now, which of these given are correct? बताइए. Okay, good. President may, by public notification after consultation with the governor of the state concerned, specify tribes as scheduled tribes relating to the state. That is correct. President may, by notification, include or exclude scheduled tribes from the list of scheduled tribes recognized at the central level. Okay. So, when we have a look over this second statement, okay, as per Article 342, Section 2, okay, such a notification regarding the scheduled tribes in a state can only be varied by the law of parliament and not by the president. Clear? So, it has to be done by parliament. Indian Constitution is silent regarding the criteria for specification of a community as scheduled tribes. बिल्कुल ठीक. Okay. So, the Constitution does not define the criteria for earmarking a community as a scheduled tribe. Clear? And that is left to the President of India to decide. So, answer is option D, 1 and 3. Clear? Next. Special provisions with regard to certain classes have been provided in Constitution Part 16 and gives the power to certain functionaries to identify and maintain list of these classes. In this context, consider the following. बताइए. Special provisions that have been given. बताइए. Okay. Now, scheduled caste. So, it is as per Article 341, the President may by public notification after consultation with governor can specify caste as scheduled caste. Okay. Second, it is incorrect because it is the President. Clear? So, this is incorrect. Okay. Third, especially socially and economically backward classes. So, this is again correct. 342A. Okay. Now, acha, first is also incorrect. First is also incorrect. Okay, yes. First is also incorrect because as per Article 341, okay, the power to provide this has been given to the certain functionaries to the President of India. President has been given under 341 and 342. So first and second are incorrect. So answer is option C, 3 only. Okay. Next. Which of the following entity initiates the proposal for deciding claims for inclusion in or exclusion from the list of scheduled tribes in India? बताइए. Okay, so this is again correct. Okay, so it is on to the state governments. Clear? Next. Parliament has framed certain laws to give effect to the provisions of the Constitution of India relating to the development of scheduled castes. In this context, consider the following. The Protection of Civil Rights Act 1955 aims to enforce the constitutional provisions enshrined under Article 17. Second, Bonded Labor System Abolition Act 1976 was enacted to reinforce the constitutional values in Article 22. Right. Okay. Now, the Protection of Civil Rights Act 1955 aims to enforce the constitutional provisions enshrined under Article 17. Clear? So, Article 17 that specifically abolishes untouchability and makes any practice of it an offense. So, first is correct. Second, bonded labor system was enacted to reinforce the constitutional values under Article 22. This is again incorrect because the bonded labor system is not under Article 22 but under Article 23 that prohibits all forms of labors. Clear? Clear? Okay. So it has to be Article 23, especially not 22. Chaliye, next. With reference to the rights of minorities in India, consider the following statements. The Constitution of India allows minorities to establish and administer educational institutions of their choice. Second, the National Commission for Minorities was established under a directive from the Supreme Court of India. Minority institutions can impart compulsory religious teachings even if it is fully funded by the Government of India. बताइए. बताइए. Now, the Constitution of India allows minorities to establish and administer educational institutions of their choice. This is absolutely correct. Okay, so Article 30 of the Constitution provides this. Second, the National Commission for Minorities was established under a directive from Supreme Court of India. This is incorrect because it was established under National Commission for Minorities Act 1992. ठीक? So third statement, minority institutions can impart compulsory religious teachings even if it is fully funded by the government of India. Okay, so minority institutions fully funded by government are not allowed to provide religious instructions to students. Clear? So this is incorrect. The answer is option A, one only. Clear? Chaliye, next. With reference to the rights of religious minorities in India, consider the following statements. The wearing and carrying of kirpan by Sikh communities protected under Constitution of India. The Constitution establishes separate personal law board for each religious minority community in India to govern their civil matters. बताओ भाई. The wearing and carrying of kirpan by Sikh community is protected under the Constitution of India because under Article 25, it is the 5 Ks which are essential for observing their faith. Okay. Second, the Constitution establishes separate personal law board for each religious community. So it is not the Constitution that has been establishing this. Clear? So they are all community formed organization and not the Constitution doing so. So second is incorrect. Answer is option A, one only. Okay. Arey Rishabh ji, how? Constitution does not talk about a separate law for Hindus, a separate law for Muslims. ठीक? चलिए, next. With reference to the special directive provided by Constitution of India for use of language in a state, consider the following statements. Every person is entitled to submit a representation for the redress of any grievance to any officer of the state government in any language used in state. State governments shall provide facilities for primary education in the mother tongue for children of linguistic minority groups. बताइए. नहीं ऋषभ जी, no need to be sorry, just keep noting these things down because they might hamper your performance in exam. Now, every person is entitled to submit a representation for redress of any grievance to any officer of the state government in any language used in the state. Clear? So, this is Article 350, okay, which deals with special directives. So, statement 1 is correct. Statement 2, state government shall provide facilities for primary education in a mother tongue for children of linguistic minorities. This is again correct. So, answer is option C, both 1 and 2. Clear? Both 1 and 2 are correct. Okay. Next. With reference to the Languages used in different courts and legislatures in India consider the following statements. The governor of a state with the prior consent of the president has the authority to permit the use of Hindi for judgments, decrees and orders of the High Court. The president has the authority to permit the use of Hindi for judgments, decrees, orders and other proceedings in the Supreme Court. Both president and governor can authorize the use of Hindi in the High Court proceedings. Fourth, currently the proceedings in the Supreme Court are conducted exclusively in English language. Okay, but still, Rishabh, these questions are useful for all the exams. बताइए. Okay, so statement 1, the Official Language Act of 1963. Now this act enables the governor of a state with the previous consent of President of India to authorize use of Hindi or any official language of the state for judgment, decrees and orders passed by the High Court. Clear? So first statement here is correct. Okay? Now, second statement, the president has the authority to permit. Now, as per Article 348, clear? So, as per this Article 348, the authority is with the Parliament and not with the President of India. Third, both President and Governor can authorize the use of Hindi in High Court proceedings. Clear? Again, this is incorrect. Again, as per Article 348, okay, so as per Article 348, the proceedings of High Court can be in Hindi if Parliament by law provides for it or the governor with the previous consent of president. Clear? So both Parliament and governor can authorize and not the president. ठीक? Currently, the proceedings in Supreme Court are conducted exclusively in English language. This is correct. Okay. So, as per Article 348, the proceedings of Supreme Court are held in English only. Clear? So, answer is option B. Next. The power to recognize a language as official language. The power to recognize a language as official language of state in India is vested in official language of a state. Okay. So, when we talk about the official language, it is Article 345 of the Constitution. And this power has been endowed upon the state legislature. Okay, it is the state legislature that has got this responsibility. Understood? Next. Consider the following statements. Statement 1. Post demonetization in 2016, Devanagari numerals are being used on the currency notes of rupees 2000 in India alongside international numerals. Second statement. According to the Constitution of India, the numerals to be used for official purposes of union shall be in the Devanagari. बताइए. बताइए. Now, in this first statement, post demonetization in 2016, Devanagari numerals are being used in currency notes of rupees 2000 in India alongside international numerals. So, this statement is correct. Okay. So, it features both international and Devanagari numerals. Second, according to the Constitution of India, the numerals to be used for official purpose of union shall be in the Devanagari. Clear? So, according to Article 343, okay, the numerals to be used for official purpose of the union shall be the international form of Indian numerals. Clear? So, it says international forms of Indian numerals, not the numerals in Devanagari. Clear? So, correct answer is option C. Okay, thus C is the answer here. Okay, next. Which of the following communities received the latest recognition as a minority community by the Union Government of India? Recently, which community was given the minority status? Now, this is slightly confusing. I want every one of you to please attempt this. Okay. So, by the Act of 1992, 5 communities were regarded as minorities in India. Okay? But the correct answer herein is option D, Jains. Jains were given minority status in year 2014. Okay, so it was in year 2014 that they were given the minority status. Clear? Next. With reference to minority communities in India, consider the following. Only the central government has the authority to notify a particular language as a minority language. Judaism is one of the religious religions notified as minority community at the national level by Government of India. सही है भाई. बताओ भाई. Okay. Now, in this, if we see, the correct answer to this is only the central government has the authority to notify a particular language. Now, this is incorrect. Okay. So, a state government has the authority to declare language as a minority language. Clear? Second, Judaism is one of the religions notified as minority community at the national level by the Government of India. Clear? So, Judaism is not recognized as a minority religion at union level. This is again correct. So, answer is option D. Neither one nor two. Okay. Yes, only is the extreme keyword. You have to watch out for it. Okay, next. Consider the following. The coalition governments have become a common phenomena in the Indian political system. Indian political system follows the multi-party system in which various political parties fight democratically for power. बताइए. बताइए. No. Statement 1. The coalition governments have become a common phenomena in the Indian political system. This is again correct. Okay. Now, when we talk about the second statement, okay, Indian political system follows the multi-party system in which various political parties fight democratically for power. So, this is correct. Clear? Okay. And it is due to this system, coalition has been a phenomena. Answer is option A. Okay. Next. Consider the following statements with respect to the usage of voter verifiable paper audit trail VVPAT. The VVPATs with EVMs were first used in Kerala. In year 1982, the voters are allowed to take printed slips of VVPAT with them. It is necessary to match and count each printed slip of VVPAT on counting day. बताइए. Okay. VVPATs with EVMs were first used in Kerala in year 1982. Now, this statement is incorrect. VVPATs with EVMs, they were used in Noxen constituency of Nagaland in 2013, okay, for the first time. Clear? In 1982, in Kerala, the EVMs were used. EVMs सबसे पहले इस्तेमाल की गई थी नॉर्थ परावूर कॉन्स्टिट्युएंसी में केरला की. ठीक. Second, the voters are allowed to take the printed slips. So, this is incorrect. So, no voter is allowed to take the VVPAT slip. It is necessary to match and count each printed slip of VVPAT on counting day. Clear? Again, this statement is incorrect. Clear? Counting of printed paper slips of VVPAT is only done, okay, in case of state legislative assembly election. Okay? And this is done randomly. Clear? It is done randomly, not for all. So, third is again incorrect. The answer is option D, none. Okay. Next. Which of the following political parties in India is a registered unrecognized party, a political party which is registered with the Election Commission of India and registered but unrecognized? आपको यहाँ you have to mention political party which is registered and recognized. Now, in such statements, the answer is simple, but you just get confused. Okay. Now, answer is absolutely option C is recognized by Election Commission as neither national or state party. Okay. Next. Consider the following statements regarding elections in India. High courts have original jurisdiction over disputes relating to elections of state legislature and both houses of parliament. Second, before 19th Amendment of Constitution, election tribunals appointed for that purpose were used for adjudication of disputes relating to the election of parliament and legislature of the states. बताइए. Okay. Now, when we talk about the statement 1, okay, the statement 1 is also correct. Okay. So, disputes relating to the elections of state legislature and union legislature are adjudicated upon exclusively by the high courts. Clear? So, they are adjudicated exclusively by the high court. So, first is correct. Now, second, before 19th Amendment of Constitution, election tribunals appointed for that purpose were used for adjudication of disputes relating to elections of parliament and legislature of the states. Clear? So, this is again correct. Earlier, election tribunals were used to be appointed for this. Okay. Now, this is no more a practice. Clear? So, second is also correct. The answer is option C. Next. Consider the following statements. Statement 1, both parliament and state legislature are empowered to make provision with respect to matters relating to elections to the state legislature. Second statement, the subject election to the legislature of state subject to the provision of any law made by parliament is sanctioned in the concurrent list of 7th schedule. बताइए. बताइए. So yes, this is Article 327. Very correct, Krishna. So Article 327 provides that the Parliament may make laws regarding elections to either House of Parliament or to the state legislature. Okay. Second, the subject election to the legislature of the state. Okay. So herein we can see that this second statement is incorrect. Clear? Why? Because according to 7th schedule, okay, the subject election to the legislature of state, take election to the legislature of state, uh, is essentially, okay, essentially it has been given under the state list of the constitution. Okay, so this has been mentioned under the state list. Okay, clear. So herein the correct answer is option C. Second is incorrect, the first is correct. Okay. Next, moving further, with reference to election in India, consider the following statements. The elections to the House of Purple, the elections to the House of People, Lok Sabha are based on universal adult suffrage. 73rd Constitutional Amendment Act reduced the voting age in India from 21 years to 18 years. बताइए, again quite simple. बताइए. सही है. Which of these? Which of these provisions? Under Article 326. Under Article 326, which of these provisions? Okay. Now, when we have a look over these, okay, now when we have a look over these, we can understand one thing, okay. So, when we talk about these, essentially, okay, the first statement, the elections to the House of People are based upon universal adult suffrage. That is absolutely correct as per Article 326. So, it has been granted as a legal right to all the adult citizens, right to vote irrespective of their background or any sort of social standing. Clear? Second, the 73rd Amendment Act. Okay, so it is not as per the 73rd, it is as per the 61st Amendment Act of 1988. Okay. Now, what was one more change that was brought in by this? Can you please suggest? What was another change that was brought in by the 61st Amendment? One was reducing the age from 21 to 18 years. Any other? Any other change that was brought in by this? बताइए. Now, along with this, the Election Commission had also become a multi-member body. Okay. Earlier, the Election Commission was a single-member body, but due to this huge influx of new voters, Election Commission also became a multi-member body. Okay. So, this statement, you must remember that this 61st Amendment Act brought in two major changes. Clear? Chaliye. So, answer is option A, one only. Next. On which of the following grounds can a citizen be disqualified from casting a vote according to the RPA 1950 and 51? बताइए. On which of these grounds? बताइए। Now, a person is a non-resident in a constituency to be registered as a voter. So, Article 326 guarantees universal adult franchise, clear, for elections to the Lok Sabha and the Vidhan Sabha. ठीक. Now, Section 19 of the Representation of Act, People's Act 1950 specifies that a person must be a ordinarily resident in constituency to be registered as a voter. ठीक. A person is of unsoundness of mind. So, Section 16 of RPA 1950 states that a person is disqualified for registration in an electoral roll if they are of unsound mind. A person committed a crime and confined in prison. ठीक. So, Section 62 of RPA says, okay, that if somebody shall not be allowed to vote if he or she is confined in a prison. Section 4, a person found guilty of corrupt practices in elections. So, Section 16 of RPA, clear, mentions person found guilty of corrupt or illegal practices under provision of any law relating to the election is disqualified. ठीक. So, answer is option D, 1, 2, 3 and 4. Clear? चलिए, moving ahead. Next, with reference to the disqualification of members of parliament under provisions of 10th schedule of Constitution of India, consider the following statements. A member belonging to any political party becomes disqualified if he voluntarily gives up his membership of such political party. Second, an independent member becomes disqualified to remain a member of the House if he joins any political party after such election. Third, no nominated member of House can be disqualified if he joins a political party. This time anti-defection law is a sure shot topic. बताइए 10th शेड्यूल. बताइए. Okay. Now, herein, if we see with reference to the disqualification of members of parliament under the 10th schedule, okay, under 10th schedule, a member belonging to any political party becomes disqualified if he voluntarily gives up his membership of such political party. That is correct. Clear? Okay. Second, an independent member becomes disqualified to remain a member of political of the House if he joins any political party after elections. So that is again correct. Third, no nominated member of a house can be disqualified if he joins a political party. Okay, so that is incorrect. A nominated member of a house cannot join a political party 6 months after taking the seat. ठीक? So the correct answer is option A, 1 and 2 only. Clear? चलिए, moving ahead. Next. Any question regarding disqualification of members of parliament arising out of defection under provisions of 10th schedule is to be decided by whom? Now, this is one amongst the easiest question of all. बताइए। Okay. So the answer is Speaker or the Chairman of respective houses. So if it is Lok Sabha, it is Speaker of Lok Sabha. Clear? If it is Rajya Sabha, it is Chairman of Rajya Sabha. Again, if it is Vidhan Sabha, it is Speaker of Vidhan Sabha. Clear? Vidhan Parishad, it is Chairman of Vidhan Parishad. Understood? So option D. Clear? Next. Which of the following changes were brought in in the anti-defection law by Constitution 91st Amendment Act 2003? बताइए। बताइए। Now, herein, a member disqualified for defection cannot hold any remunerative political post. Clear? So, on ground of defection, shall also be disqualified to hold any remunerative post. Okay. Second, it established a special tribunal to adjudicate on defection law. No such establishment has been done till date. So, answer is option A, one only. Clear? Okay. Next. Yashwantrao Balwantrao Chhavan Committee 1967 in India was set up to बताइए। YB Chhavan 1969, he was the then Home Minister. Okay, so he was to examine the problems of political defections. Okay. Next. All India Services plays a significant role in maintaining administrative continuity and integrity across the country. In that context, which of the following statement about All India Services is incorrect? Incorrect. All India Services can be created by an act of parliament. All India Services officers serve both the union and state governments. The recruitment rules for All India Services are determined by the union government. All India Services officers cannot be transferred from one state to another state. Rishabh will discuss it. Okay, first of all, let us take up the topics. Then I'll take up this doubt. Okay. Now, if we have a look here, okay. Now, all India services. Okay. So first and foremost, all India services are those mentioned under Article 312, okay, 312 of the Constitution. Clear. Now, in this, we need to understand how specifically, okay, these things work. Clear. So, herein, if we talk about these statements, all India services can be created by an act of parliament. Okay. So, all India services can be created by an act of parliament. Okay. So, this statement, if we see, okay, this statement is specifically, okay, this statement, we can see that this is correct. Okay. Article 312 talks about the all India services. Clear? So, this is correct. All India services officers serve both the union and the state government. Okay. So, all India services by definition, what does it mean? That the officials hold positions, so officials who have been recruited and trained by the union, but they are serving under the state. Clear? So, they are holding positions in the central as well as the state governments. Clear? And they are serving the both. See, the recruitment rules for all India services are determined by the union government. So, this is again correct. Clear? So, as per Article 320 of the Constitution, Article 320 of the Constitution, the rules, okay, shall be framed by the Government of India to govern the recruitment and service conditions. Fourth, all India service officers cannot be transferred from one state to another state. Now, this is incorrect. So, this is the answer, option D. Clear? Next. With reference to Constitution of India, consider the following statements about all India judicial services. All India judicial services. The All India judicial services can be created by the Council of States with a resolution passed by 2/3 members of the council present and voting. All India judicial services cannot be created without the recommendation of Chief Justice of India. The All India judicial service shall not include any post inferior to that of a district judge. बताइए. बताइए. All India judicial services. Okay. The All India Judicial Services can be created by Council of States with a resolution passed by 2/3 members of the council present and voting. Okay, this is correct. So, according to Article 312, the Parliament can create new All India services, including All India Judicial Service. Clear? So, Article 312 talks about All India services, including All India Judicial Services. ठीक? Second, judicial services cannot be created without the recommendation of Chief Justice of India. So, this is incorrect. There is no provision for the recommendation of Chief Justice. Third, the All India Judicial Service shall not include any post inferior to that of a district judge. Clear? So, this is again correct. So, answer is option A, 1 and 3 only. ठीक? Next. Consider the following statements. President of India make rules for regulating the recruitment of persons to public service until provision in that behalf is made by Parliament. Members of civil service of union holds office during the pleasure of the President. Third, no person who is a member of civil service of the union can be dismissed or removed by an authority subordinate to the one that has appointed it. बताइए. Okay. Now, President of India make rules for regulating the recruitment of persons to public service until provision in that behalf is made by the Parliament. So this is correct. Clear? This statement is correct. Article 309 empowers the Parliament. Okay, very good. Very good, Rishabh and Krishna. Very good. So it is Article 309 that is specifying the rules regulating the recruitment of persons. Second, members of civil service of union holds office during the pleasure of the president. This is again correct. ठीक? So these specifications are mentioned under Article 310. Okay. No person who is member of civil service of union can be dismissed or removed by authority subordinate to the one appointing it. This is again correct. Clear? So answer is option D, 1, 2 and 3. Clear? Next. With reference to the Delimitation Commission, consider the following statements. It is a constitutional body established under provision of Article 324 of Constitution of India. The Chief Election Commissioner of India is the ex officio chairperson of this commission. Lok Sabha as well as state legislatures can change the orders of this commission. Right. Delimitation, basically fixing of the boundaries, territorial constituencies, and this is carried out after every census. बताइए. Good. Now it is a constitutional body. Now this is incorrect. Now this is not constitutional. It is statutory body. Okay. Why this is a statutory body? Because it is created under the Delimitation Acts. Okay. Second, the Chief Election Commissioner of the India is ex officio chairperson. Now this is again incorrect. Clear? So a judge of Supreme Court acts as the chairperson. Third, Lok Sabha as well as state legislature can change the orders of this commission. This is again incorrect. Delimitation Commission is highest body whose orders will be laid before Lok Sabha and state legislative assembly, but modifications are not permissible by them. Okay, so answer is option D. ठीक? Option D is the correct answer. Very good, Krishna. 82 and 170 are the articles. Okay. चलिए, moving ahead. Next. In context of public service commissions in India, consider the following statements regarding Joint Public Service Commission. It is a constitutional body like the UPSC. Joint state PSC can be created by an act of parliament on the request of state legislatures concerned. At present, the states of Punjab and Haryana are the only states to have a joint state PSC. बताइए. Now, it is a constitutional body like UPSC. Just remember UPSC and state PSC. They are constitutional body. Clear? Joint State Public Service Commission is a statutory body. So first statement is incorrect. Clear? So it is a statutory body. Okay, so it is created by an act of parliament on the request of concerned state legislatures. Okay. Joint state PSC can be created by an act of parliament on the request of state legislatures concerned. Correct. At present, the state of Punjab and Haryana are the only states to have joint state PSC. Wrong. Clear? So it was only for a time when Haryana was carved out of Punjab in 1966. Clear? As of now, no states in India have a joint state PSC. Clear? So answer is option A, only 2. ठीक? Next. Which of the following statement is incorrect? The chairman of UPSC shall be ineligible for further employment either under central or state government. Chairman of state PSC shall be eligible for appointment as chairman of UPSC only but not for any other employment under union. Member other than chairman of UPSC shall be eligible for appointment as chairman of UPSC or state PSC only but not for any other employment under union or state government. D. Member other than the chairman of state PSC is eligible for appointment as member UPSC. Now this is service conditions. Now, the answer is option B. Chairman of a state public service commission shall be eligible for appointment as chairman of UPSC only, but not for any other employment under union or state government. Now, why this statement is incorrect? Clear? Because according to Article 319, chairman of state PSC on ceasing to hold office is eligible for appointment as chairman or a member UPSC or as chairman of any other state PSC. Clear? So it is clear? Chaliye, next. Consider the following statements regarding the Sangeet Natak Academy. Now, it is statutory body established under Ministry of Education. Second, the chairman of academy is appointed by President of India. Okay, which of the statements given above is or are correct? बताइए. Good. Now the answer, it is a statutory body. So it is not a statutory body. Okay. Basically, Sangeet Natak Academy is called the National Academy of Music, Dance and Drama. Okay. And it is an autonomous organization. Okay. So it is an autonomous organization that has been created by an executive resolution of Ministry of Education, Government of India in 1953. Okay. So first statement is incorrect. Second, the chairman of academy is appointed by the President of India. This is correct. Okay. And the chairman, whosoever is appointed for a term of 5 years. Clear? So answer is option B. Okay. Next. As per Constitution of India, in which of the following cases union or state government gains ownership of property as there is no rightful claimant of the property? Escheat, lapse, bona vacantia, for succession. बताइए। I hope all of you know these terms. Okay, I hope all of you know. Now, escheat, essentially, this term means death of a person, okay, uh, interstate without any heir, okay. ठीक, so it is death without an heir, clear. Now, lapse essentially means termination of rights through disuse or failure to follow appropriate procedures, okay. So that is termination of rights. Okay. Now, bona vacantia, it means property that does not have any owner. ठीक है. So property that does not have any owner is bona vacantia. Clear? And fourth is succession. So यहाँ पर essentially we can see that answer is option A, 1, 2 and 3 only. ठीक. So these have been mentioned under Article 294 to 300 of the Constitution. Clear? And basically Article 296 deals with situation wherein property would have gone to the British Crown or the princely rulers but now goes to the government due to lack of rightful claimants. ठीक? And essentially we can see why succession is not correct. Clear? In succession, the ownership of property is transferred from British to the government of India, but not due to the absence. Okay. So this succession is transfer, not due to the absence. Clear? Chaliye. With reference to the rights and liabilities of union or state government under part 12 of the constitution, consider the following statements. The limits of territorial waters are specified by the law made by littoral states of India. Second, the limits of the continental shelf are specified by the law made by Parliament of India. Third, the limits of exclusive economic zone are specified by the executive action of President of India. Now, which of these is or are correct? सही है. Now, we have seen that there has been this question around territorial waters, exclusive economic zones. It has been a lot in exam. Okay. Now, when we see this, with reference to rights and liabilities of union or state governments under part 12 of the constitution, consider the following. First statement, the limits of territorial waters are specified by the law made by littoral states of India. ठीक. Now, as per the UN convention, okay, so as per the UN convention, UNCLOS, United Nations Convention on Law of the Seas, it defines territorial sea as a 12 nautical mile zone from the baseline of the coastal zone. So, as per Article 297 of the Indian Constitution, the limits of territorial waters are specified by laws of Parliament and not by those of littoral states. Clear? So, first is incorrect. ठीक. Second, the limits of continental shelf are specified by the law made by Parliament of India. Okay. Now, when we see this second statement, okay, the continental shelf comprises the seabed and subsoil of the submarine areas. Okay. So, that is beyond the territorial sea to a distance of 200 nautical miles. Okay. So, 200 nautical miles from the baseline. Okay. So, this second statement is correct. Third, the limits of exclusive economic zone. okay, are specified by the executive action of President of India. So EEZ, okay, they are subject to the specific legal regimes which are established in this part. Clear? So under these, the rights and jurisdiction of the coastal state and the rights and freedoms of the state are governed. Clear? So it is given as per Article 297. Okay, section 3, the limits of EEZ are specified by law made by Parliament of India. Okay, so it is by Parliament and not by the President. Clear? So essentially the correct answer is option C, 2 only. Okay, option C, 2 only is the correct answer. Okay, so all of you who are part of this session, please do let me know. Okay, are you all benefiting of the out of these sessions? Are you all benefiting through this question practice? I hope all of you are able to revise a lot of things through this. Okay. So whatever new information you are getting, I would request you to please keep noting it down. Okay. So once you start revising after a week or so, that will help you a lot. Okay. So do let me know that all of you are enjoying this or not. Okay. Chale, moving ahead. Next. In exercising its executive powers, the union or the state government have the authority to enter contracts for any purpose. But the constitution lays down certain conditions which must be fulfilled before entering such contract. In this context, consider the following conditions. First, contracts must be expressed to be made by parliament or state legislature. Second, contracts must be executed on behalf of the president or governor of the state. Third, contracts must be executed by such person in such manner as the president or governor may direct or authorize. Right. This is as per Article 298. Okay. Now, if we have a look, contracts must be expressed to be made by the parliament or state legislature. Okay. Now, all contracts made in exercise of executive powers shall be expressly made by the president or by the governor of the state. So, it is not by the legislature bodies. Okay. So, it is not to be carried out by the legislature. It has to be either by the president or governor. Clear? So, because it is on behalf of the government, okay, and the executive heads are either the president at the union level or the governor at the state level. Contracts must be executed on behalf of the president or governor of the state. So, this is correct. Third, the contracts must be executed by such person in such manner as the president or governor may direct or authorize. So, this is again correct. Clear? So, answer is option B. Okay, option B is the answer. Next, consider the following functions of the government: making peace or war, regulating foreign affairs, acquiring foreign territory, raising the armed force. Fifth, regulating essential commodities. Which of the above given functions can union government be sued for torts committed by its officials? So basically, you can consider it as a certain sort of liabilities. सही है. Okay. Okay. So consider the following functions of the government. Okay. Now, if we talk about the tort liability of a state, okay, it states that union or state can be held liable for civil wrongs. Okay. Now, herein the options first, second, third, and fourth are essentially the responsibility areas. Clear? So it is only option 5, and thus the answer is option B. Clear? 1, 2, 3, and 4 are responsibility areas of the government. Clear? Next. With reference to Union Public Service Commission, consider the following. As per the Constitution of India, the number of members of the Parliament is determined by the Commission is determined by the Parliament by law. The Union government may, by regulation, provide for exercise of additional functions by the Union Public Service Commission. A member of UPSC can be removed from office by the President only based on the grounds mentioned in the Constitution. बताइए. बताइए. Powers and functions of UPSC. चलिए. Now herein UPSC, which is mentioned under Article 315 to 323 of the Constitution. Now, as per the Constitution of India, the number of members of UPSC of Commission is determined by Parliament by law. Okay. So Constitution provides that chairman and other members shall be appointed by the President. Clear? So the total strength has not been mentioned and it is left to the discretion of President. Clear? So under Article 316, it has to be the President. ठीक. चलिए. Second, now the second statement, if we say the union government may by regulation provide for exercise of additional functions by UPSC. Okay. Now statement 2 is also incorrect. Clear? Because as per Article 321, Okay, as per Article 321 of the Constitution, an act made by Parliament or as the case may be the legislature of state may provide for the exercise of additional functions. Clear? Okay, upon the UPSC or the state PSC. Clear? So it is again not the same. Third, a member of UPSC can be removed from office by the president only on the grounds mentioned in the Constitution of India. ठीक? So this is correct under Article 317. Clear? So the chairman and members shall be removed from his office by order of president on the grounds mentioned in the Constitution. Clear? Okay. So along with this members and chairman, ठीक है, the president can also remove the chairman or any member of UPSC for misbehavior. Okay. चलिए, so the correct answer herein is option C, 3 only. Clear? चलिए, next. With reference to the Election Commission of India, consider the following statements. Statement 1, the Election Commission of India is a quasi-judicial body. Okay, so quasi-judicial has to be understood here. Election Commission has the power to review any result on its own once the polls are completed and the results are declared. बताइए. बताइए. So all of you who are part of the session, please do let me know. Please keep answering. Okay. Now, Statement 1, Election Commission of India is a quasi-judicial body. So this statement is absolutely correct. Okay. Quasi-judicial body, that its procedures are similar to that of a court of law. Clear? And essentially does not enjoy penal powers. Clear? Second, Election Commission has the power to review any result on its own once the polls are completed and the results are declared. Clear? The Commission cannot review anything on its own. ठीक है? This review can be done only once an election petition has been filed before the High Court. Clear? So, this is incorrect because election petition has to be filed before the High Court. So, answer is option C. Clear? Chaliye, next. With reference to the Finance Commission of India, consider the following statements. It recommends principles governing the grants in aid to the states out of the Consolidated Fund of India. Second, Constitution of India puts an obligation on the Union Executive to implement the recommendations of the Finance Commission of India. Third, Finance Minister causes every recommendation made by the Finance Commission of India to be laid before each House of Parliament. बताइए. Finance Commission. Okay. Now, when we talk about Finance Commission, it is Article 280. Now, it recommends principles governing the grants in aid to the states out of the Consolidated Fund of India. So, first is correct. Okay. Because the Finance Commission's main function is to recommend the distribution of revenue between the central and the state, which includes recommending the principles for granting aids to the states that need financial assistance. Okay. Second, Constitution of India puts an obligation on the Union Executive to implement the recommendation of the Finance Commission of India. Now, this is incorrect. Clear? Now, the role of Finance Commission is only advisory. ठीक? So their role is only advisory. There is nothing binding. Clear? Third, Finance Minister causes every recommendation made by Finance Commission of India to be laid before each house. Clear? So it is nowhere laid down in the Constitution that recommendation shall be laid to the by the Finance Minister. Finance Commission itself submits its report to the President of India, not to the Finance Minister. Clear? So third is again incorrect. The answer is option A, one only. Clear? Chaliye, next. With reference to the National Investigation Agency of India, consider the following. It was established in the backdrop of 2008 Mumbai attacks. NIA works under the administrative control of Department of Personnel and Training, Government of India. Third, the powers of Director General are similar to the powers exercisable by a Director General of Police in respect of police force in a state. बताइए. NIA. बताइए. So, देखिए, it was established in the backdrop of the 2008 Mumbai terror attacks. That is correct. So, NIA was established in 2009. Okay, under the provision of NIA Act. Clear? So, this is a central counter-terrorism law enforcement agency. Okay. Second, the NIA works under the administrative control of DOPT, Government of India. This is incorrect. So, NIA is headed by a Director General appointed by the central government and works under the Ministry of Home Affairs. The powers of Director General are similar to the powers exercisable by a Director General of Police in respect of the police force in a state. Clear? So, now when we have a look on this statement, this is correct. Okay. So, we can see the powers of DG are similar to powers exercisable by a DGP in respect of police force in a state. Chaliye, next. With reference to National Disaster Management Authority, consider the following. The ex officio chairperson of National Disaster Management Authority is the Minister of Home Affairs. NDMA works under the administrative control of the Union Ministry of Home Affairs. Disaster Management Authority. Okay. Uh, Now, the ex officio chairperson of NDMA is the Minister of Home Affairs. This is incorrect because herein it is the Prime Minister. NDMA works under the administrative control of Union Ministry of Home Affairs. Clear? So, NDMA is a apex disaster management body which works under the administrative control of Ministry of Home Affairs. Clear? So, administrative and logistical support is carried out through this ministry. Okay, in the disaster management conditions. Clear? So, answer is option B, 2 only. Next, with reference to CBI, consider the following statements. According to Delhi Special Police Establishment Act, CBI can take up suo motu investigation of offences notified in Delhi Special Police Establishment Act only in the Union Territories. Second, central government can authorize CBI to investigate a crime in a state but only with the consent of the concerned state government. Third, only Supreme Court of India can order CBI to investigate a crime anywhere in the country without the consent of the state. बताइए. Creation of CBI as recommended by the Santanam Committee 1962-64. Okay, so CBI in itself is not a statutory body and it is deriving powers from the Delhi Special Police Establishment Act of 1946. Clear? First statement, CBI can take up suo motu investigation of offences notified in Delhi Special Police Establishment Act only in the Union Territories. Yes, suo motu, it can be taken up only in the UTs. Clear? So, taking up investigation by CBI within boundaries of state requires consent of state. Clear? So, in the second statement, it is correct because it requires the consent of the states. Third, only Supreme Court of India can order CBI to investigate a crime anywhere in the country without the consent of the state. So, both the Supreme Court and the High Courts can direct CBI. Clear? Not just the Supreme Court. Supreme Court plus High Court, they can order. So, answer is option A, 1 and 2 only. ठीक? Next. With reference to elections in India, consider the following. Part 15 of the Constitution of India comprises provisions pertaining to elections. The Chief Election Commissioner and other election commissioners are appointed by President of India. Third, since independence, the Election Commission of India has functioned as a 3-member body. बताइए. Now, Part 15 of Constitution of India comprises provisions pertaining to the Election Commission of India. Okay, so Part 15, Article 324. The Chief Election Commissioner and other election commissioners are appointed by the President of India. So, this is again correct. Okay. Since independence, the Election Commission of India has functioned as a 3-member body. No. Okay. So, Election Commission originally a single-member body. Okay. And full-fledgedly, it has been working as a 3-member body only since 93. Clear? So, Additionally, it was in 1988 after the 61st Amendment when 2 members were added. Then again it was reduced to a single member body, but in 93 it became a full-fledged 3-member body. Okay. So third is incorrect. The answer is essentially option A, 1 and 2 only. ठीक? चलिए next. In context of difference between the Representation of Peoples Act 1950 and Representation of People Act 1951, consider the following. So this is very, very important, very sharp question. Okay, differences in between RPA 1950 and RPA 1951 are being asked. Okay, so take up. The RPA 1950 governs the nomination of candidates for elections, while 1951 focuses on registration of voters. The RPA 1950 provides for registration of political parties, while 1951 deals with the allocation of seats in parliament and legislative assemblies. The RPA 1950 provides for procedures for delimitation of constituencies, and while the RPA 1951 deals with the provisions to curb corrupt practices and other electoral offences. Okay. बताइए प्लीज सजेस्ट. Now just remember one thing, that this RPA Representation of Peoples Act 1950, it talks about the pre-election preparation. Okay, so everything around pre-election. So preparation, voter registration, preparation of electoral rules, everything is covered in this. Clear? The RPA 1951, it talks about the conduct of elections. It talks about conduct of elections. Clear? So thus first statement is incorrect. Second, the RPA 1950 provides for registration of political parties. Now this is again incorrect, because the Representation of Peoples Act 1950 provides for allocation of seats, delimitation. Okay, so that is being discussed. That is covered under this. Okay, and RPA 1951, okay, that talks about the registration of parties. Okay. Third, the Representation of Peoples Act 1950 provides for procedures for delimitation of constituencies, and while the Representation of Peoples Act 1951 deals with provisions to curb corrupt practices. Now this is correct. Clear? So just remember, this Representation of Peoples Act 1950 is talking about everything pre-election. Okay, conduct of elections is ultimately under the Act of 1951. Clear? So statement 3 is correct. Okay. Next. With reference to the cotton production in India, consider the following statements. The cotton yield in India is consistently increasing from the past 5 years. Second, cotton exports has shown an increasing trend in the past 5 years in India. चलिए मतलब not specifically a topic around polity. This question is not very apt. Okay, next. Consider the following statements about the Central Information Commission. Now, this Central Information Commission has been in UPSC examination for quite some time. Okay, and these questions are being asked regularly. Okay. Now, and consider following statements about CIC and Information Commissioners in light of recent amendments to the RTI 2005. The tenure of CIC and Information Commissioners has been fixed at 3 years. Second, the salaries and allowances of Chief Information Commissioner and Information Commissioners are determined by the central government. Third, this amendment gave new power to CIC to impose penalties for non-compliance with its orders. Right. By the recent changes that have taken place. Okay. So, all of you who are part of it, please do let me know the answers. Actually, now herein if we see the tenure of Chief Information Commissioner, Information Commissioners has been fixed at 3 years. Okay. Now, before 2019 amendment, the Chief Election Commissioner and the Election Commissioners had a fixed 5-year tenure. Okay. Or they had to serve until the age of 65 years, whichever came first. Now, post amendment, there is no fixed tenure for Chief Election Commissioner and the election commissioners, and their tenure is now at the discretion of the government. So, this has been very much in news that the autonomy of this office has already been taken up by the union government. So, first is incorrect. Second, the salaries and allowances of Chief Information Commissioner and Information Commissioners are determined by the central government. So, that is correct. Clear? So, after their amendment, the salaries and allowances are now determined by the central government. Clear? Prior to this 2019, they were at par with the Chief Election Commissioner and the election commissioners. Okay. Third, this amendment gave new power to the Chief Election Commissioner, Chief Information Commissioner to impose penalties for non-compliance with the orders. Clear? So, this is incorrect statement. Okay. This is incorrect and answer is option B, 2 only. Okay, option B, 2 only is the correct answer. ठीक? चलिए, next. Consider the following statements regarding the functions of National Human Rights Commission. Okay, answer with respect to the National Human Rights Commission. To independently probe any suspected human rights violations or oversight in their deterrence by a public servant. Second, to intervene in any proceedings involving an allegation of violation of human rights pending before a court with the approval of the concerned court. Third, to visit jails and detention places to study the living conditions of inmates and make recommendations thereon. Fourth, to provide legal aid to the victims of human rights violations. बताइए. Okay. Now, when we have a view over this, okay, the role of the National Human Rights Commission. Now, National Human Rights Commission is a statutory body that has been created under the Protection of Human Rights Act of 1993, and Commission is a basically a watchdog of human rights in India. ठीक? To independently probe any suspected human rights violations or oversight in their deterrence by a public servant. This is correct. Clear? So, NHRC is empowered to inquire into any violation of human rights or negligence. Second, to intervene in any proceedings involving an allegation of violation of human rights pending before a court with the approval of the concerned court. Clear? So, again, this is correct. NHRC has the authority to intervene. Okay. And regarding any pending cases of violation. Statement 3, to visit jails and detention places to study the living conditions of inmates and make recommendations thereon. So, this is again correct. Okay. And fourth statement, to provide legal aid to the victims of the human rights violation. Okay. So this statement is not to provide legal aid is wrong. Clear. So it can recommend to the government to provide, but it itself cannot. ठीक. So answer is option C, only 3. Okay. चलिए next, moving ahead, next. Consider the following statements regarding reservation of seats in municipalities. The seats filled by direct elections for scheduled caste and scheduled tribes are reserved in every municipalities in proportion to their population in the municipal area. Second, not less than one-third of the total number of seats filled by direct elections are reserved for women in municipalities. Third, the state legislature may provide for manner of reservation of offices of chairpersons for SCs, STs and women in the municipalities. बताइए. The question around the 74th Amendment Act. '74th Amendment Act of 1992. Okay. Now, this 74th Amendment Act, it added Part 9A, okay, which includes the provisions for the reservation of seats also. Okay. Now, Statement 1 says, the seats filled by the direct elections for scheduled caste and scheduled tribes are reserved in every municipality is in proportion to their population in the municipal area. That is correct. So everything has to be done in proportion to its population. Clear? Statement 2. Not less than one-third of the total number of seats filled by direct elections are reserved for women in municipalities. So this is again correct. Clear? Third, the state legislature may provide for manner of reservation of offices of chairpersons of SC, STs and women in the municipalities. So this is again correct. Clear? So all of these provisions have been mentioned under Article 243T. Clear? चलिए. So answer is essentially all three. ठीक है? All three is the correct answer here. Next. Consider the following electoral reforms in India: lowering of voting age from 21 years to 18 years, introduction of electors photo ID card, third, introduction of braille signage features in EVMs in general elections to Lok Sabha, fourth, introduction of none of the above option in electronic voting machine. Which of these is the correct chronological order? So you have to arrange the same in the correct chronological order. Okay, in the correct chronological order. Okay, now when we talk about these electoral reforms, okay, so these reforms have been very much in news, okay, because they were the ones which had brought in landmark reforms in the electoral system of the country. Clear? Now, when we talk about the lowering of voting age from 21 years to 18 years, so that was brought in by the 61st Amendment Act of 1988. ठीक? So it was brought in by the 61st Amendment Act. Now, electors photo ID card, EPIC. Okay. Now, this essentially came from 1993. Okay. Introduction of braille signages in EVMs during the general election, it came out in the 2009 general elections. Okay. And the nota option came in 2013. ठीक है. So the correct answer is this 1, 2, 3, 4 only. Okay. Next. With reference to Panchayati Raj institutions in India, consider the following statements. The state legislature may delegate functions specific to the preparation of plans for economic development and social justice to the panchayats. Second, the constitution allows for the delegation of public distribution system to panchayats by the state legislature. सही है. Okay. So, with respect to this Panchayati Raj institutions in India, okay. So, when we come across the first statement, so it is as per Article 243G. Okay, as per Article 243G, the state legislature may endow the panchayats with such powers and authorities as may be necessary to enable them to function as institutions of self-government. Okay. So, first statement is correct. The state legislature may delegate functions specific to the preparation of plans for economic development and social justice to the panchayats. Second, the constitution allows for the delegation of public distribution system to panchayats by the state legislature. Yes, this is again correct. Clear? It is one amongst the 29 functions in the 11th schedule. Okay. So, answer is option C, both 1 and 2. Okay. Both 1 and 2 here are correct. Okay. Next, a person who is convicted for the offences under Prevention of Insults to National Honours Act 1971 is disqualified from contesting in elections for 6 years. In that context, consider the following. Okay, the Prevention of Insults to the National Honour Act 1971. Okay, it contains certain actions which are considered disrespectful. Okay, so it has got offences insulting the national flag, constitution and the national anthem. ठीक? So first is burning the national flag. Yes, this is covered under this. Clear? So act of burning national flag is covered under this, and in this prevention of insults to the national honors. Okay. Assaulting a member of parliament, this is not covered anywhere. So it is just three things. Clear? National flag, constitution, national anthem. ठीक? Using the national emblem for commercial purposes, again this is not part of it. Criticism of Constitution of India demanding the amendments, again this is not part of it. Using the Indian national flag by printing it on napkins or handkerchief, yes, this is insult to it. Okay, so answer is option D, 1 and 5. Okay, option D, 1 and 5 are part of it. Next. With reference to the Council of States, consider the following. The representatives of a state in Rajya Sabha are elected by the elected members of the Legislative Assembly and Legislative Council of the state. Now, the Constitution of India has fixed the term of office of members of Rajya Sabha to 6 years. Okay. चलिए. So again, this is an important. Okay. Now, questions around the elections to Rajya Sabha, Lok Sabha, even though these are some very, very basic topics, okay, but at times the candidates are very much confused in them. Okay, so they are relatively the ones that create confusion amongst the candidates. Okay, चलिए. Now, when we talk about this, the representatives of state in the Rajya Sabha are elected by the elected members of Legislative Assembly and Legislative Council. Now, this is incorrect because when we talk about these, okay, so as per the constitution, it is only the Legislative Assembly. Clear? So, it is Legislative Assembly and not the Council. The Constitution of India has fixed the term of office of members of the Rajya Sabha to 6 years. Clear? Now, it is essentially not the basically the Constitution. It is the Representation of People's Act 1951. Clear? It is RPA 1951, which is option D, neither one nor two. Okay. Next. Which of the following statements is correct about seats reserved for scheduled tribes in the parliament? Seats are reserved for scheduled tribes in both Lok Sabha and Rajya Sabha. Out of Lok Sabha seats allotted to the state, these seats are reserved for scheduled tribes in that state based on the proportion of their population in that state. C. To contest a reserved seat for scheduled tribes in parliament, a candidate must be recognized as a scheduled tribe in state from which they are contesting. D. A member of scheduled tribe cannot contest election from an unreserved seat. Okay. Now, in all of these questions, okay, first and foremost, you must eliminate things. Okay. So, by simply eliminating options, you will be able to mark your answers. Okay. Now, when we talk about the elimination, okay, options that can be easily eliminated are option D. It can be easily eliminated. Clear? Then option A is easily eliminated. Okay, we know that there is no reservation in case of Rajya Sabha. Option B and C. Out of Lok Sabha seats allotted to a state, the seats are reserved for scheduled tribes in the state based on the proportion of their population. So this is absolutely correct. Okay. So answer herein is option B. Okay. So we can talk about Article 330 here. Okay. So Article 330 which reserves the seat for SCs and STs in Lok Sabha, and 332 reserved seat for SCs and STs in the state legislative assembly. Clear? Next. Consider the following. If a member of any house of parliament voluntarily gives up membership of her political party, okay. Second, if an independent member of a house joins any political party. Third, if a member is elected as a speaker and voluntarily gives up their party membership or rejoins the party after ceasing to hold the office. Fourth, if a member of parliament switches party after being elected to Lok Sabha. In which of the above circumstances will the anti-defection law under 10th schedule be applicable? इनमें किसमें this anti-defection law shall be applicable? Okay. Now, if a member of any house of parliament voluntarily gives up membership of her political party, yes, this is a valid ground. If an independent member of a house joins any political party, yes, this is again a valid ground. If a member is elected as speaker and voluntarily gives up their party membership or rejoins the party after ceasing to hold the office. Now, in this situation, the exemption is provided. Clear? So, the exemptions have been provided under Article 310 310 of the Constitution. Fourth, if a member of parliament switches party after being elected to Lok Sabha. Yes, the defection works. Okay, so it is option B. Okay, it is option B wherein the provisions are applicable. ठीक, चलिए next. Recently, there were many instances in which the government of India has temporarily suspended internet services across the country in order to maintain public order. In this context, consider the following statements. First, the Indian Telegraph Act 1885 regulates the matters related to internet suspension in India. Second, in India, internet suspension may be ordered on grounds of public emergency and public safety. Third, at present, India has no regulations that stipulates a maximum time limit for internet suspension. बताइए. Suspension of internet. बताइए. Okay. Now, the government has been temporarily suspending internet services across the country time and again, and this is purely done to maintain the public order. Okay, so this has been basically an important tool to control the law and order situation. Now, first statement around the Indian Telegraph Act of 1885 regulates the matters related to internet suspension in India. Clear? So, currently suspension of telecom services including internet is governed by Temporary Suspension of Telecom Services Act. Clear? And this notification has also been part of the Indian Telegraph Act. Okay. Second, in India, internet suspension may be ordered on grounds of public emergency and public safety. Okay. So, as per the temporary suspension of telecom services, the internet shutdown may be ordered on grounds of emergency and public safety. So, this is again correct. Third, at present, India has no regulation that stipulates a maximum time limit. Okay. So, basically, in this situation, okay, the Supreme Court had a very landmark judgment, okay, in the Anuradha Bhasin case. ठीक? So, in the Anuradha Bhasin case 2020, okay, so this can be for a maximum duration of 15 days. Clear? Okay, for a maximum duration of 15 days. However, the revised rules do not require the publication of suspension orders. Clear? So, this was a very landmark judgment wherein the right to access internet was also considered a fundamental right under Article 21 and 21A of the Constitution. Clear? So, this basically judgment came in the backdrop of internet restrictions imposed in Jammu and Kashmir. Clear? Chaliye, next. So, answer herein is option B, only 2. Consider the following passage. This Constitutional Amendment Act abolished the then existing classification of states into 4 categories A, B, C, D. It reorganized them into 14 states and 6 UTs. The above paragraph refers to which of the following constitutional amendment? बताइए. This statement is regarding which amendment? So this was quite easy. Okay, it has been option C, the 7th Amendment Act of 1956. Clear? So 7th Amendment Act aimed to streamline and simplify the administrative divisions in the country. Okay. Next. Parliament session, effects on Parliament and declared by whom? So now this has been a very usual pattern. Okay, in almost all UPSC exams. Clear? So this is a new examination question form that is being asked regularly. Okay. Now parliamentary session, effects on Parliament and declared by whom? Clear? So dissolution ends the life of Lok Sabha and President of India. So all three are correct. Okay. Prorogue. Prorogue is basically terminating the sittings of the House. Clear? So termination of the sittings of the House is proroguing. Clear? Okay. But in the row 2, this proroguing is basically not the sitting. It is end of the session. And this proroguing is done by the President of India. Clear? Adjournment is done by the presiding officer. Okay. Third is adjournment terminates the session of the House. So again, this is incorrect. Adjournment is termination of a sitting of the House. Clear? So these two rows are incorrect. The answer is option A, only one. Understood? Next. With reference to the Speaker pro tem of Lok Sabha, consider the following statements. Now, Constitution of India specifies the qualification for a member of Parliament to become the Speaker pro tem. The Speaker pro tem decides the date for the election of the Speaker to the Lok Sabha. Okay, so now essentially, if we see these statements, the question is too easy. Okay. Now, the Constitution of India specifies the qualification for a member of Parliament, okay, to be the Speaker pro tem. Clear? Now, as such, the Constitution does not allow, does not lay down any such qualification. Okay, and as a convention, typically the senior most member is appointed to it. ठीक? Second, Speaker pro tem decides the date for election. Now the dates of election are decided by the President of India. Clear? So answer is option D, neither one nor two. Okay, option D, neither one nor two is the answer. ठीक? Next. Which of the following statements with respect to the post of Speaker of Lok Sabha and the Chairman of Rajya Sabha is incorrect? Okay, Speaker of Lok Sabha and the Chairman of Rajya Sabha, and it is incorrect. Clear? Unlike the Speaker, the Chairman of Rajya Sabha's Electoral College consists of the members of Rajya Sabha only. Okay, so incorrect statement has to be marked. So this is incorrect. Okay, but just let us go through the other statements. Unlike the Speaker, the Chairman of the Rajya Sabha is not a member of the House. This is correct. Unlike the Speaker, the Chairman of Rajya Sabha cannot vote in the first instance when the resolution for his removal is under consideration. Yes. Okay. Now, like the Speaker, the salaries and allowances of the Chairman of Rajya Sabha are also fixed by the Parliament. This is correct. Clear? So, answer is option A. Acha. Now, the confusion might come at this statement. Unlike the Speaker, the Chairman of Rajya Sabha cannot vote in the first instance when a resolution for his removal is under consideration, because while the process of removal is going on, the Speaker shall participate as an ordinary MP. Okay, so herein he shall be participating as an ordinary MP, and thus he will be participating in voting at the first instance also. Whereas when the removal of vice president or the chairman is going on. Since he is not a member, he cannot vote. Clear? Chaliye, next. With reference to the Secretariat of Indian Parliament, consider the following statements. The Secretariat of each house is headed by a Secretary General who is appointed by the presiding officer of the house. Okay. Second, the pay scale and position of Secretary General of Lok Sabha is equivalent to Cabinet Secretary to the Government of India. बताइए. Okay. Now, when we talk about the Secretariat of the Parliament, this Secretariat has been mentioned under Article 98 of the Constitution. Okay. And Secretariat of each house is headed by a Secretary General who is appointed by the presiding officer of the house. Clear? So, this statement is correct. The pay scale and position of Secretary General is at par with Cabinet Secretary. That is again correct. So, answer is option C, both 1 and 2. Okay, option C, both 1 and 2 are correct. Okay. Next. The Constitution of India provides that every member of either House of Parliament shall make and subscribe an oath. With reference to this, consider the following. Okay. Oath is again a very confusing part in some of the questions. All the members of Parliament must take an oath to bear true faith and allegiance to the Constitution of India. Unless an MP takes the oath, he or she cannot vote and participate in the proceedings of the House. Okay. Now, statement 1 says all the members of Parliament must take an oath to bear true faith and allegiance to the Constitution of India. Yes. So, the oaths are taken in the name of God and on the secrecy of office. Clear? Statement 2, unless an MP takes oath, he or she cannot vote and participate in the proceedings of the House. Clear? So, they does not become eligible for parliamentary privileges, immunities and the procedures taking place. Clear? So, answer is option C, both 1 and 2. Okay. Next. In context of the rights of members of Parliament, consider the following statements. Every member of Parliament can participate in the proceedings of a House of which he or she is not a member. Second, a person can remain a minister for 6 months without being a member of either House of Parliament. Okay, again, now these statements are again very obvious. Okay. Statement 1, every member of Parliament can participate in the proceedings of House of which he or she is not a member. Clear? So, in this situation, this statement is incorrect. Okay. Now, this privilege is given only to ministers. Clear? So, ministers can participate in the proceedings of each house. Okay. And not the members. Members shall have to participate in the proceedings of house of which they originally belong to. Okay? So, this first is incorrect. Second, a person can remain a minister for 6 months without being a member of either House of Parliament. That is correct. Okay. So, that is correct. Answer is option B, 2 only. ठीक? चलिए, next. In context of 0R in Indian Parliament, consider the following statements. Clear? In the context of the 0R. Clear? So, 0R is basically an Indian parliamentary invention. Okay. And this 0R is basically the time gap between the question hour and start of agenda. Clear? So, it is an informal device which has not been mentioned in the conduct of business rules and procedures of respective houses. Clear? 0R starts immediately after the question hour and lasts until the regular business. Clear? Yes. Okay. Usually taken up around 12 noon. Unlike the question hour, 0R is mentioned in rules and procedures. No, this has not been mentioned. Okay. Third, the practice of 0R is adopted from the British Parliament. Again, this is incorrect. Why? Because this convention of 0R has been our parliamentary innovation, has been our invention, and has not been inspired from any other source. So answer is option A, one only. Next. With reference to no confidence motion in Indian Parliament, consider the following. While a no confidence motion is introduced by the members of the opposition party, the confidence motion is introduced by the government in power. The no confidence motion should state the reason for its adoption in Lok Sabha. Now, when we talk about the no confidence motion, okay, now no confidence motion is basically to ensure the confidence of the House in the ruling government. So, Article 75 says that the Council of Ministers are collectively responsible to the Lok Sabha and they shall enjoy the office unless and until they hold the majority in Lok Sabha. Now, when we talk about this statement, a no confidence motion is introduced by members of opposition party. The confidence motion is introduced by government in power. Clear? So, this is absolutely correct. Okay. So, under Rule 198 of Lok Sabha, it allows the opposition to challenge the government's majority and their ability to govern. Okay. And once the no confidence motion fails, the ruling government immediately comes up with the confidence motion to claim their majority in the House. Okay. Second statement, the no confidence motion should state the reasons. So, it is incorrect. Okay. No confidence motion, no reason is required. Clear? No reason is required. So, answer is option A, one only. ठीक? चलिए, next. Consider the following types of motions: cut motion, adjournment motion, and privilege motion. So, previously, as there was a statement in no confidence motion that it required the reason. Okay, so it is not the no confidence motion which requires a reason. It is the adjournment motion that requires the reason. Okay, chaliye. So, Akash and few more candidates have joined lately. Okay, so we are just upon the ending part of the session. Okay, chaliye. Now, when we consider this, okay, when we consider this about the cut motion or these, now cut motion is again a very prominent thing. Okay, so all the students who have been confused in motions, just remember, whenever you are solving the question, just remember that these motions are primarily a weapon into the hands of the opposition. Clear? So, they are primarily a weapon in the hands of opposition and must be considered in the similar form while you are answering the questions. ठीक? Consider the following. Cut motions, adjournment motion, privilege motion. Which of the motions given above, if passed, adopted by the concerned House of Parliament, would necessarily amount to the expression of want of parliamentary confidence? Parliamentary confidence. Clear? Now, cut motions are only moved and discussed in the lower house and not passed. Okay, as the process, as the government enjoys majority support. Clear? So, the passages of these, if passed, amounts to the expression of want of parliamentary confidence in the government, and in case it is rejected, it may lead to the resignation. Clear? So, option 1 is correct. Okay? Because in adjournment motion, it censures the government. Okay, and privilege motion is a concerned individual. Clear? It is against a concerned individual, a concerned minister, a concerned member of parliament, provided they have undertaken a breach of parliamentary privilege. ठीक? चलिए. Next. consider the following statements with reference to procedures of special mention in Parliament. Okay, special mention in Parliament. Now, if we talk about the special mention in the Parliament, okay, so any term when we come across like special mention, they are by and large a tool to raise issues of public importance in the Parliament. ठीक? So mechanism of special mention is specially confined to the Rajya Sabha, and they are like notices of the Lok Sabha. ठीक? Now, it is mechanism available in Rajya Sabha only, again correct, clear? So it is equivalent to notices in the Lok Sabha. ठीक? Second, the matter which cannot be raised in question hour and half an hour discussion can be introduced through special mentions. Again, this is correct. Clear? So, anything that cannot be raised in question hour, half an hour discussion, short duration question, calling attention motion, ठीक है, can be raised here. ठीक? So, this is again correct. So, answer is option C, both 1 and 2. Okay. So, answer is option B, 1 and 2. Option C, both 1 and 2. ठीक? Now, with reference to the legislative procedure in Parliament of India, consider the following statements regarding the private members bill. First, a private members bill can be introduced only with the prior permission of the President of India. Second, a private members bill can be introduced to propose the amendment to the Constitution of India. Third, so far no private member bill has become an act. Okay. Clear? Take up. Now, a private members bill can be introduced only with prior permission of President of India. Now, this is incorrect. Okay. So, a private member bill, okay, only requires a notice. It does not require permission of the President of India. Clear? So, period of notice to introduce a private members bill is 1 month, and there is no requirement of President's assent here. ठीक? Second, a private members bill can be introduced to propose the amendment to the Constitution of India. Yes, it can be taken up. Clear? It can be taken up to amend the Constitution. So far, no private members bill. Now, this is again an incorrect statement. Clear? So, many bills, around 13, 14 private members bill have become an act. Clear? So, this is again incorrect. So, answer is option B, 2 only. Okay, option B, 2 only is the correct answer. Okay. Next, moving ahead, a bill introduced in the Parliament is considered as money bill if it deals with which of the following matters. Okay. Now, money bill in the Parliament under Article 110 of the Constitution. Clear? So, there have been a few exceptions to the money bill, and what all is considered under a money bill, definition of a money bill. ठीक? So, Article 110 talks about this. Now, first, imposition of fines and penalties. Okay, this is exception to a money bill. Now, regulation of borrowing of money by the government of India. Yes, so any sort of appropriation taking place in the consolidated fund shall be a part of it. Clear? Third, imposition of new tax by local authority. Again, this is an exception. Clear? Again, this is an exception. So, anything that is covered under this will not be part of this. Clear? So, answer is option A, 2 only. Option A, 2 only is the correct answer. ठीक? Next, with reference to the money bill, consider the following statements. The Rajya Sabha does not have the power to amend a money bill but can reject it. Second, the Lok Sabha can either accept or reject all the recommendations of the Rajya Sabha regarding a money bill. Third, when a money bill is sent to the president for assent, the president can exercise an absolute veto. Okay. So, herein, if we can see, okay, so with reference to money bill, okay, now you can consider the statement 1. The Rajya Sabha does not have the power to amend a money bill but can reject it. Clear? So, Rajya Sabha has got restricted power under Article 109. Okay, under Article 109, the Rajya Sabha can only discuss these provisions, can neither reject nor modify. ठीक? And then the bill has to be returned within 14 days. ठीक? Second, the Lok Sabha can either accept or reject all the recommendations of Rajya Sabha regarding a money bill. This is correct. Third, when a money bill is sent to the president for assent, the president can exercise an absolute veto. Okay. Now, usually a money bill is introduced with the recommendation of the president. Clear? Now, president cannot exercise suspensive veto over it. Clear? Otherwise, all the other vetoes are available to the president. Clear? So, president can exercise an absolute veto over a money bill as well. ठीक? Okay. So, answer is option C, 2 and 3 only. Okay. Next. The Constitution of India provides for a joint sitting of houses of legislature to resolve deadlock over certain bills. In this context, consider the following. Okay. Now, constitutional amendment bills in the parliament. Okay. Second, financial bills in the state bicameral legislature. Third, ordinary bill in states having bicameral legislature. Fourth, money bill in the parliament. Okay. Now, the Constitution of India provides for a joint sitting. Now, the provisions of joint sitting are applicable to which all types of bills? Clear? That has to be discussed. Now, joint sitting has been mentioned under Article 108 of the Constitution. Clear? Constitutional amendment bill, joint sitting cannot take place. Okay? Joint sitting cannot take place for constitutional amendment bill. Okay? Financial bill in state. Now, in state, there is no provision. No provision of a joint sitting. ठीक? Ordinary bill in state having bicameral legislature. Again, in state, there is no provision. Fourth, money bill in the parliament. Again, in the case of a money bill in the parliament, again there is no provision. Okay, so in none of these, the answer is option D. None of these. Okay, in none of these conditions can a money bill be a joint sitting. Now, just remember, a joint sitting can be introduced only in parliament. Okay, either for an ordinary bill or financial bills under Article 117. So, this is under 107 and this is under 117. Clear? Except these provisions, no joint sitting can take place either in parliament or in the state legislature. ठीक? चलिए, next. Which Constitutional Amendment Act gave the status of state to Nagaland and made special provisions for it? Clear? So, this essentially was asked in the examination. So, it was 13th Amendment of 1962. Clear? So, it gave a unique identity to the Nagas. Okay? Chali. Now, next, so essentially, okay, in the entire time duration of almost 4 hours, okay, we had been able to cover and solve only around 100 questions. Clear? So, no issues. We can have a session again. Okay, we can have a session again. Okay, because I've been discussing every background detail also for the question. So we had been able to do only around 100 questions in almost 4 hours duration. No issues. We'll have another session, okay, for 150 more questions. Now, with reference to the joint sitting of Parliament, consider it is presided over by the President of India. In addition, the motion of thanks on the President's address is passed in a joint sitting of Parliament. Third, a bill in the joint sitting is deemed to be passed when it is passed by a majority of total numbers of both the houses present and voting. Clear? So now when we have a look over this, clear? Under Article 108, when we discuss, it is presided over by the President of India. Wrong. It is presided over by the Speaker of Lok Sabha. If Speaker is not available, then it will be Deputy Speaker of Lok Sabha. If not, it will be Deputy Chairman of Rajya Sabha. ठीक? Second, in India, the motion of thanks on the President's address is passed in a joint sitting of Parliament. Clear? Now, when we talk about this second statement, okay, as per Article 87 of the Constitution, the President's addresses both houses of Parliament in a joint sitting at the commencement of first session. However, motion of thanks on this address is considered and voted upon separately. Okay, and motion of thanks is again, it becomes a prerogative which has got greater importance in Lok Sabha. Clear? So, second is again incorrect. A bill in the joint sitting is deemed to be passed when it is passed by a majority of total number of both the houses present and voting. Yes, so it is majorly simple majority. ठीक? So correct answer is option A, 3 only. Clear? Option A, 3 only is the correct answer. Clear? Okay. So essentially we had been able to do around 100 questions in time of around 3 hours and 40 minutes. Clear? No issues. Okay. So do let me know. I hope all of you would have liked this session. आपको session अच्छा लगा होगा and all of you would have been benefited. You would have got some better practice. Please do let me know. Krishna and Rishabh had been part of the session throughout this entire duration. Okay. So in case you are also targeting the IAS examination 27 or in year 28, okay, then GS Foundation batches in English, Hindi as well as in Hindi-English combination English are being launched. Okay, the fresh batches are starting tomorrow, okay, from 7th of May, and you can use the code SRM Live to avail maximum discount. Clear? Chaliye. So thank you all for joining me in this session. Okay, so please do let me know how do you like this session. Okay, so thank you, Krishna. So we'll be back. We'll have more sessions time and again. Okay, and we'll be there with you until you excel in your examination. So this was all from